In this third clip, I would like to talk about domestic courts. And before I turn to the reading question, which was basically about when domestic courts can actually enforce international human rights law and its provisions, I want to say a few words about the important role that domestic courts play in general. And once again, we can hark back here to the very first clips I made, where we talked about the separation of powers and the fact that governmental power in particular is supposed to be limited. And who does that? It's of course the domestic courts. Very much depending, and I like the way that the textbook phrases this, very much depending on the constitutional arrangements that are in place. So how exactly domestic courts come to deal with rights, whether that's human rights or constitutional rights, or maybe both, will depend on the constitutional arrangement as addressed in the first video. Now, in some and arguably probably in many constitutional systems, courts will be providing what is often referred to as judicial or constitutional review. What is meant by this? It means that rights guarantees, so individual rights, are being used indeed to scrutinize, for example, acts of Parliament, and this then is one of the most important manifestations of the separation of powers. The textbook mentions the very classical textbook examples here, which are of course the United States and also Germany, both of them having very strong high courts, namely the Supreme Court in the United States and the Federal Constitutional Court in Germany, which is very assertive when it comes to the protection of individual rights for historical reasons. Now, there are two important preconditions that have to be met for such judicial review to take place, and here we're actually already coming very close to the answer that is required for the reading question. And these aspects are, on the one hand, justiciability, and on the other hand, legal standing. Justiciability first is about whether a right is actually invocable before a court, whether it is concrete and actionable enough for a court to actually come to a decision on whether there has been a breach or not. Think, for example, of the right to development. Now, that's not a right that is being assured under international law, for that matter, in instruments. However, one could very well imagine it to be put down in a constitutional system as a constitutional right. Now, it's hard to see how exactly a court would find the right to development to be breached or not, given that we don't know exactly what this right entails. And this, at least in this rather simplified example, would be an instance in which a right is not justiciable. Many other rights, such as the freedom of assembly, but also, of course, social and economic rights, such as the right to food and in some sense the right to housing as well, will be actionable. The other precondition or prerequisite for there to be judicial review is that there is legal standing. Now, often we will of course be having a victim of a violation, an individual victim of a violation, accessing the courts, and there the question of legal standing will not be particularly problematic. The person has been negatively affected and claims there to be a breach, so that would then be quite straightforward. However, in some systems we have also broader sort of legal standing rules that include, for example, also group-based claims or collective actions. For example, in the Netherlands, and we talked about the Mothers of Srebrenica case here, but also, for example, MPs, so members of parliament, could bring a constitutional challenge. That's, for instance, one very prominent way in which such cases take place in Germany. To know these kinds of conditions, you of course will have to look back at the constitutional arrangements in specific states, so it is hard to make very general claims here, but it is important to keep those two aspects in mind. When they are met and when cases come about, you really do have domestic courts creating a so-called, and I really like the term from the textbook here, repository of rights. Cases that very clearly set out how rights are implemented in specific factual circumstances and how they ought to be given real practical effect by the government. So in this case, domestic courts are really at the front line of the implementation of human rights. In particular, in common law systems where there's also a relatively strict stare decisis rule. If you remember your introduction to law course, this is the rule, the principle that precedents or previous judgments ought to be recreated and respected in subsequent case law, but also more generally in other legal systems, because of course whenever we do have a judgment, in particular by constitutional court, this is a very important source of law, a very important subsidiary source. So let's turn to the reading question, which was what determines whether human rights, as opposed indeed to constitutional, domestic constitutional rights, are given effect by domestic courts. And here the answer, the straightforward answer would be to say, well, it is about the applicability of human rights, and that is somewhat of a circular explanation. So let me briefly flesh that out in more concrete terms. Now, one of the features of specific constitutional arrangements that indeed differ per states is the status that international law has in domestic legal systems. And this, of course, brings us back to the 200 level course on international law, where we made this very general distinction between monist countries on the one hand and dualist countries on the other one. The authors also draw a very careful distinction here, and we can follow them in this regard, starting of course with the dualist system, in which international law, and in this case therefore also international human rights law and the treaties, are not directly applicable in the domestic legal system, but first have to be implemented through a domestic legal act. Think, for instance, of the 1998 Human Rights Act, which is basically a one-to-one copy of the European Convention on Human Rights into the UK legislative format. So in this context, human rights, international human rights at least, would not be able to be enforced by domestic courts. Now, obviously, in many systems, we will still have constitutional guarantees, which, as in the UK context, are often even just one-to-one manifestations of the same provisions, and therefore it doesn't make much of a difference in practice. However, it will not be an enforcement of international human rights law as such. And then, of course, we have the monist systems, and the archetypical example here is the Netherlands with its constitutional systems, where in fact human rights treaties are directly applicable in the Dutch courts, which therefore means that these human rights instruments perform the same function that constitutional rights perform in a more dualist state. So they can be invoked directly and individuals can rely on them directly in domestic courts. Now, ideally the story would end here with me basically saying, well, in monist states, therefore, domestic courts can simply enforce human rights law. It is not quite as simple as that in most cases. Consider, for example, the United States, which strictly speaking is a monist country. However, a distinction there is being drawn between self-executing international law provisions and non-self-executing human rights provisions. And it's important to understand this distinction because it basically means that some provisions are directly applicable and others are not, and have therefore to go through Congress, be implemented in domestic legislation, very much in the way that a dualist system would function in order to become a part of domestic law. And this is in fact why in the United States we have a relatively closed system, because most international law provisions are actually being considered to be non-self-executing, which means that Congress first has to pass and implement these rights provisions. This concludes the clips for this week. I look forward to discussing the domestication and in particular some of the theoretical dimensions behind the domestication of human rights law with you in the live session.